So the first big legal issue comes to the power of the speaker to disqualify MLAs, and that's why this whole sort of the legal aspect of this political tussle between Ashok Gehlot and Sachin Pilot began, because Pilot and the other 18 MLAs with him went to the Rajasthan High Court to challenge the disqualification notices issued to them by the Speaker of the House, C.P. Joshi. Now, in these notices, the Speaker had asked them to show cause why he shouldn't disqualify them, given that the Congress has claimed they've indulged in anti-party activities. The Congress complaint says that by failing to attend meetings, by running off to Manesa, by essentially all their conduct in the last few days, they have voluntarily given up membership of their party and therefore are liable to be disqualified. Now, this comes from paragraph 21A of the 10th schedule of the Constitution, which is the anti-defection law, which says that the Speaker can disqualify an MLA or an MP, a member of a House, if they've voluntarily given up membership of their party. Now, this doesn't have to require some sort of resignation letter. It can be inferred from a member of the House's conduct, according to the Supreme Court. Now, the Speaker is looking into it on the basis of this complaint. Sachin Pilot and his MLA say, look, we're just expressing dissent. This is our right to freedom of speech. This is not grounds for disqualification. And that's what they've said in the High Court. Now, this itself is not a problem. The problem is that the High Court has sort of taken up this matter before the Rajasthan Assembly Speaker has made a decision. The Speaker hasn't yet disqualified these MLAs. And that's the big legal debate here as to whether or not the courts can get involved with this till the Speaker makes a decision. Because there is a Constitution bench judgment from 1992, the Gehlot case, which said that the Speaker's decision Speaker has full discretion to make these decisions. They're the ones who get to decide things under the anti-defection law. But once they've made a decision, that can be subject to judicial review. Now, here the Speaker hasn't yet made a decision, so the Speaker, his lawyers, and the Congress lawyers, Kapil Sibal, Abhishek Manu Singhvi, have said both in the High Court and the Supreme Court that, look, there is no question of the courts taking cognizance. On the other hand, Sachin Pilot's argument is that before this gets any further, this needs to be resolved. And the High Court has agreed to look into this. Even the Supreme Court was willing, till the Speaker has now obviously withdrawn his plea. But again, the Speaker could go back to the Supreme Court, and we could see this whole issue coming up again, because they are saying, and it does appear that on the basis of the Gehlot judgment, the court should not be getting involved at this point, and it should be left to the Speaker to make a decision. There is now questions of constitutionality, of whether expressing dissent can be considered as voluntarily giving up membership of your party. But again, while that is something for the courts to look into, the Gehlot judgment had upheld the entirety of paragraph 2 of the 10th schedule. So this may seem like it's relitigating something which has already been decided by a Constitution bench of the Supreme Court. The second big issue is the power of the governor when it comes to summoning the assembly, and whether they have some sort of discretion to not do so when the council of ministers ask for this. This is because Ashok Gehlot and his cabinet have asked the governor of Rajasthan, Kalraj Mishra, to summon the legislative assembly from 31st July onwards. Mishra did not take a decision over the weekend, raising sort of concerns over the coronavirus pandemic, and on Monday he's issued a bunch of clarifications to the Gehlot government after it reiterated its request, saying that, look, maybe give 21 days notice, what are the measures you're taking for social distancing, are you planning to conduct a trust vote? And now these clarifications may seem like they're reasonable clarifications to raise at this point, but the question is, does the governor have the power to raise these concerns at this point and not just accept whatever the chief minister and the council of ministers is saying? Because in law, it looks like the governor doesn't have this power, and it's pretty settled, because we've had two judgments of the Supreme Court, in Shamsher Singh and then in the Nabim Rabia judgment from 2016. The Shamsher Singh is from the 70s, it's a judgment, 2016 Nabim Rabia, where they say that while the governor is the one who has the power to summon the assembly under Article 174 of the Constitution, Article 163 of the Constitution says that the governor acts on the aid and advice of the Council of Ministers. So if the Council of Ministers is saying something, the governor has to do it, and they don't really have any discretion. So now, because the governor has still not called the assembly session, we could now see Gehlot and his council ministers have now approached the Rajasthan High Court, or perhaps even the Supreme Court, to get the governor to do what they think is required at this point. The third issue is the one which comes back to those BSP MLAs and what we do about them. Because now, while the Rajasthan High Court has said the BJP legislator's petition where he was challenging their merger with the Congress was not valid, the BSP has issued a whip over the weekend telling these 6 MLAs that your merger was not valid under law because, we, the whole national party of the BSP, have not agreed to it. And so you must now vote against the Gehlot government if it comes to a trust vote. Now, the problem is that when we look at the concept of merger under the 10th schedule, it does not appear to support what the BSP are saying here. So even if Mayawati and the sort of high command of the BSP don't agree to a merger in a state, the concept of merger is defined in paragraph 4 of the 10th schedule to be deemed to happen when 2/3 of the legislature party in question here decide to go with another political party. Now that could be either to form a new political entity or to just join with the other party. And that's what the MLAs in Rajasthan seem to have done, the BSP MLAs, because the 2/3 number is met here in terms of the legislature party. Because the legislature party is basically those who have been elected to a particular house from a particular party. So while you may have the main BSP, the BSP legislature party in Rajasthan is those who have been elected to the assembly elections in 2018. Now, they've gone ahead and agreed to the merger. So can the national party get involved? Well, the law doesn't seem to allow that. But interestingly, there's been no Supreme Court or High Court judgment on this. So we could see this taken up now again in the courts and become another issue which could affect the status of the Gehlot government when a trust vote is actually called.